rise. Justices of the Appellate Division, Supreme Court, First Department. You all persons having business with the Appellate Division. Draw near, your attendance, and shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division, First Department. We are now in session. The only case on the calendar is Stevens versus New York State Division of Criminal Justice. I received your written requests for time. Before I decide how much time to give you, do you want to indicate today what time you want? Let's hear from the appellant. How much time?
I'd appreciate the full time, Your Honor, but happy to reduce it as needed to 7 minutes.
Okay.
Which one is request 10 minutes?
Same. All right. Here's what we're going to do. I am going to give the appellant 12, 3 reserved for rebuttal, and I'm going to give the respondent 12 minutes. Obviously, we are familiar with the case, and to the extent that we are asking you questions and we may exceed the time, we can be somewhat flexible about it since you are on the only case on the calendar. So I would ask appellant to come to the podium.
May it please the court, Doran Satno from Gibson, Dunn & Crutcher, representing petitioners, along with our co-counsel, the Legal Aid Society. Respondents lacked the authority to implement the FDS amendment that is at issue on this appeal. We know that for at least 2 fundamental reasons. First, we know the New York legislature did not authorize respondents to enact the FDS amendment.
But counsel, before we even get to that, isn't the executive law, doesn't it confer broad authority on the respondents to be able to promulgate standards for matches within the DNA database?
Your Honor, the authority that the New York legislature authorized the respondents with respect to the data bank specifically, as you note, is to promulgate standards for identifying matches between the forensic DNA.
But broad authority, would you concede that it's broad authority?
The authority to promulgate standards, Your Honor, is not broad at all. It is narrowly circumscribed to identifying a match. And what respondents did here in enacting the FDS amendment was implement a search regime that applies only when there is not a match or a partial match to the DNA records in the data bank. So even if you...
I know you have that argument. You really seize on the word match. But I thought, to me, that argument seemed very technical, and that match may have been used in different contexts, and it's hard to understand why family DNA wouldn't be a match, at least of some alleles. It does involve a matching process. So I'm not sure about the statutory language argument, but isn't there a broader consideration here about the separations doctrine, regardless of whether match includes family DNA or doesn't?
Absolutely, Your Honor. The first Boreali factor, the lens through which we analyze the separation of powers, provides that when a regulation enacted by an agency entails a competing policy choice, when it implements a value judgment that only the legislature is authorized to make, it violates.
But how is this a value judgment?
The value judgment here endorsed by the FDS amendment is that crime runs in families, and that guilt can be genetically associated, and that therefore, if you are biologically related to someone who has been convicted
I think that's just completely speculative, that's the basis for requiring family matches.
But the purpose of the familial DNA search regime is to enhance the pool of potential suspects in a crime.
The pool remains the same. The pool is the people convicted of certain crimes. They're in the database. That pool never changes.
The pool in the databank, specifically the DNA records in the databank, may not change, but by using the familial search technique, that allows law enforcement to identify the family members of those convicted offenders and to investigate them.
So taking that, partial matches are permitted, right?
Partial matches,
So partial matches can, maybe not in an intentional way, but can turn up the same results. So what's really the difference? It's just, essentially, it's an intentional search versus a search of the entire database using a partial match, no?
a couple of responses to that, Your Honor. First, the result of a partial match is not the same as the result of a familial search. By definition, a familial search is conducted only in the absence of a partial match. So, strictly by definition, as an initial matter, they cannot be the same because the familial search occurs only when no partial match is found. But secondly, a familial search uses an entirely different mechanism than the partial match searching. The partial match searching arises inadvertently in the intentional search for an exact match. That intent is critical here. The potential net.
Counsel, let me, I'm trying to understand, before we even go down that road of familial searches, your argument, unless is it your argument that the respondents here did not even have the authority to promulgate the regulations for familial search? I mean, that's it, right? I mean, they didn't have the authority to do that?
They didn't have the authority to do that under their enabling statute, Your Honor. In addition, there's a separation of powers violation.
That's the threshold question. I mean, what the familial search does, you could get into the technicality. Your main argument is like they can't promulgate this regulation. It wasn't within their authority to do that, correct?
Yes, I mean, that is.
So what happens then, in terms of the legislature? I thought I read in the record here that the legislature, when they're not capable of implementing or passing a statute, why can't the regulatory commission step in and fill in some blanks? What's wrong with that?
Because what respondents were doing here was by no means filling in the blanks. What they were authorized to do was to implement standards for determining a match. And what the familial search regulations do is they authorize a use of software, a new type of software that is not involved in the search for an exact match or a partial match, a new type of software whose intentional purpose is to generate a list of potential biological relationships between the DNA, the convicted offenders in the DNA data bank, and the DNA submitted for comparison. That is a new use that is out.
Right. So the real key here is that what the regulation does is it authorizes a use that otherwise was heretofore not known with this data bank, correct? A use of the DNA. To come within the separations doctrine, as I understand it, it has to be because this is a policy-laden decision. So what are the policies that are at issue here in deciding whether to use family DNA as an investigatory thing? Tool. Yeah, tool. Thank you. I knew there was a word for it. And not. What were the policy considerations that the agency was wrestling with or had to wrestle with in order to come to this conclusion?
Those policy considerations included, Your Honor, the fact that individuals who have family members whose DNA records are in the data bank should be subject to increased police scrutiny. They decided that the privacy interest...
a privacy issue in the DNA by people who are otherwise innocent.
Yes, Your Honor, there is...
Against the effectiveness of this tool, right?
That's correct, Your Honor.
And by the way, the effectiveness of the tool is by no means uncontroverted. Let's just put it that way. It's a national debate that we're having about, is this a good tool, and do the benefits outweigh the privacy problems that may arise from it?
That's correct, Your Honor. It's an extremely controversial tool that is a subject of national debate, again, because it is based on this very controversial premise that there is a genetic association with criminality, and that as a result of that, the privacy interests of New Yorkers who have not committed any crimes, but who simply have relatives who have committed crimes, means that they should be subject to increased scrutiny.
Well, see, that's what I don't understand, Counselor. My question is, why is this not a viable investigatory tool? I mean, what they're doing is by this partial match, the investigators are therefore able to perhaps go out and find the individuals who are matched to that DNA, and therefore who would be the suspect or person of interest in a particular case.
Yes, the familial DNA searching technique is an investigatory tool, but that doesn't mean that the agency was authorized to implement it. In authorizing this investigatory tool, they were stepping outside the realm in which they were permitted to regulate the data bank, and they were deciding what types of crimes would justify familial search.
Okay, so if we assume that they did have the authority to promulgate this, this regulation, then you do concede or admit that it is a viable investigatory tool. Is that correct?
Well, the viability of familial searching as an investigatory tool is hotly debated, but it is correct, Your Honor, that familial searching is a technique that can be used to help solve crimes. But just
You know, what is interesting, Counselor, is in doing some research and reading the briefs, et cetera, I noted that this was an argument that was also made when we first started DNA matches and the DNA data bank, and what crimes should or should not go into the data bank. So it seems that what we're really looking at is, because it's something new, and it's, I think one of my colleagues mentioned, is something new and something that perhaps we did not initially perceive could be done with the DNA data bank.
yes, Your Honor, it is something new entirely, and it is something new that steps beyond the bounds of which the respondents were able to regulate. The pool of potential suspects that result from a familial search is far broader than what the agency was authorized to do. And further, the process of approving the familial search application also involved...
Well, why do you say that it's much broader than what the agency was authorized to do?
Because
was not the agency authorized to ensure or to, you know, assist in terms of this investigatory tool?
No, Your Honor. What the agency was authorized to do was to promulgate standards for the determination of matches, and for the agency to implement a regime, a search regime, when there is no match or partial match to the DNA records in the data bank, in order to bring within the sweep of potential suspects the family members of convicted offenders. That raises a policy judgment and a value of the type that New York courts would deem
you know, these family members are not going to be, my understanding is that the family members would not be arrested. The family members would not be detained. My understanding is that the family members would be questioned, or there would be investigation in terms of seeking who the individual is that they're looking for, right?
Right, but the peculiar risk of being subject to an increased
But
law
counsel, I want to, right there, you hit it right on the mark. That's the question I wanted to ask. The way I see it, the way I'm understanding this argument here that you're making is that this familial DNA investigatory tool, it's a quicker process and it expands the pool, but it's almost as if it's like the internet nowadays in terms of people searching for someone's name. In the old days, it was all out there. The information was there, but you had to really, you know, do a lot of footwork to get the information. Now it's at your fingertips. With the DNA, the familial DNA search here, the investigatory tool, the police or the investigators had the notion in terms of figuring out who the family members are of a particular suspect that they're having. I mean, it's no different, right? I mean, we're just talking about how fast and how, in terms of speed now, in terms of investigations, no?
Not at all, Your Honor, because we are using the DNA records, the specific DNA information of the convicted offenders, as a means to identify potential biological relationships. And,
No, I'm sorry. I cannot accept that premise. There's a crime committed, a very specific crime committed. There's sufficient amount of DNA. Isn't it just a simple investigatory tool, like anything else, that may lead to leads and addresses, that kind of thing? Isn't that all that's happening here?
No, but what's happened here is the agency has decided to implement a new regime that involves a profound balancing of policy considerations that they were not authorized to make. Only the legislature was authorized to enact familial searching. It involves profound policy decisions that were not within the realm of the agency's expertise.
I think my colleague asked you about what the policy considerations were, and I'm sorry, I didn't really hear an answer to that. What are the policy considerations you're saying that were made here?
The policy considerations are the degree of biological relatedness between a convicted offender and another individual that should subject them to falling within the sweep of the familial search, as balanced against the privacy interests of New Yorkers who have not committed any crimes that warrant their inclusion of their DNA records in
What's the
database.
difference between that and the old days when the investigator would just start searching around and then find, oh, this person's related to this potential suspect, and go knock on their door and then start questioning them?
No, but the problem here is that the agency was not authorized to use a new form of DNA software to identify familial relationships based on DNA uncovered from a crime scene.
So I'm sorry. Your argument really is, we're not really here to decide whether this is a good investigatory tool or not. Just who should be the body that makes that policy decision according to your belief that this is a policy-laden decision.
That's absolutely correct, Your Honor.
Okay.
The critical issue here is who's allowed to decide.
Because your light is way over, and I am going to cut you off. We do understand the argument. Let's hear from your adversary.
Thank you, Your Honor.
We'll ask him challenging questions as well. Good afternoon.
Good afternoon, Matthew William Grieco.
Okay, we're going to start off with the other side of the coin for you, which is here. Isn't the decision to decide whether to use familial DNA a balancing of privacy rights and genetic information versus the needs of law enforcement? Isn't that a policy evaluation?
No, Your Honor, the policy judgment here was made by the legislature, and there's two specific policy judgments.
Well, how could they, let me just explore that a little bit. How could they have made that policy determination when, in fact, at the time the enabling legislation was passed, familial DNA was not known as an investigatory tool?
It is precisely because it was not known at that time, but that the legislature understood that there would be evolution in the science, that the legislature made the policy judgment to create a DNA subcommittee to, and I'm quoting from 995B13B, evaluate and assess all DNA methodologies proposed to be used for forensic analysis. Unquote.
Well, is this a methodology or is it a use? And is there a difference?
It is a methodology or a use. I don't see a distinction here between those two. And the other key policy judgment here that the legislature made was in Executive Law Section 995B6A, where they made the judgment that the purpose of the DNA data bank was for use in connection with the investigation of the commission of one or more crimes. And so when you take those two policy judgments, the decision to delegate the judgments about the scientific basis for regulations to a DNA subcommittee, and the fundamental purpose of the data bank to use to investigate one or more crimes, one of your honors observed that this is comparable to other investigative techniques that have existed in the past, where it is being used as an investigative lead. And of course...
Well, except that we have to factor in that maybe or maybe not, that in genetic information you have a privacy interest. This wasn't DNA that was collected voluntarily. It's not stuff that's just out on the internet that people put out there. This is stuff that was involuntarily collected, so it has a different standard, and that there is at least some authority out there that you have a privacy interest, and I'm talking about the innocent people, in your genetic material.
But neither petitioner's DNA is in the data bank or will ever be collected, nor can either petitioner's name ever be disclosed.
That's your standing argument, right? That's your standing argument.
That is a standing argument, but it also relates to the merits. That is the basis on which they...
But if, in fact, the agency has the authority, they could change the rules. They could change the rules of the game on this. Right now, it's very circumscribed. It's only certain crimes. But assuming that they weren't operating in violation of the separation of powers, they could change that. They could increase the crimes. They could decrease the crimes, right? They could change the method of review. Couldn't they?
And the legislature made the judgment that an expert agency is the right repository for forming those policies, and that judgment by the legislature.
The question is, even if it's, but under Borelli, even if it's a valid delegation, if it violates their separation of powers, then it does not stand. So there's really a two-tiered analysis here, right? It's
does-
not just the language of the statute.
It does not violate the separation of powers because the data bank is still being used in a purpose that is consistent with the policy judgment made by the legislature, which is to investigate crimes.
Does it matter that, I mean, as I looked at some of the literature that was quoted in the briefs, that it is very controversial whether it is particularly effective, that there's at least the governmental study of the labs indicated that it's only in a rare circumstance that a familial DNA investigation will result in an actual conviction. Does that matter? Should it matter?
It only matters in context, and the context is that, as we lay out in our brief, by definition, any case in which a familial search is going to be performed is an extremely difficult case in which other investigative methods have already failed, in which law enforcement has been finding it challenging to solve the crime. So it should not surprise us that there's going to be, it should not surprise us, nor should it trouble us that there may be a modest rate of return on successful searches. As our brief lays out, there are successful instances of familial searches, and also, as our brief lays out, the number of searches that have been approved in New York has been quite small.
Well, I saw that in your brief, and I thought that was interesting. Should there not be some type of consideration as to exactly what the threshold showing must be in order to get the familiar DNA information?
I'm not entirely sure I understand the question, but if I...
So what showing has to, the other issue that I had is what is the showing that is necessary in order to obtain the familiar DNA information?
Oh, sure. So the regulation lays out the requirements, and you have to demonstrate that it is one of a very small list of enumerated serious crimes. You have to designate that other investigative methods have failed. You have to show that you have a strong quality sample, and you have to show a basis for believing that this sample is connected to someone who would be the perpetrator of the crime.
So one of the arguments I made was that this was insufficient in terms of the showing that has to be made, and that this could change. It seemed to be some fluctuation in terms of exactly what the standard that has to be met.
Right, but any change in the standard would require a new rulemaking, which would be subjected to a new arbitrary and capricious review if anyone challenged it. And again, the fundamental consideration here is that the legislature made the judgment, and it's a judgment that's reflected throughout the statute, not only in the provisions.
Well, when the legislature passed the law initially, and they essentially delegated because it was such a new, novel tool, the DNA, is that,
right.
we know how quick the legislature likes to move around here, right? So that they delegated that sort of rulemaking authority to the commission. Let you guys, I'm going to put together the commission, you guys look at it, and you guys figure it out as it evolves. I mean, that's exactly what's been happening with this.
That's right, Your Honor, and this is the quintessential kind of case where delegation to an administrative agency makes sense and is traditionally.
And you can't do the rules, and you can't do the rules. I mean, you got the sunshine laws. I mean, it's a rulemaking authority. You got to go through all the procedures of the Administrative Procedure Act. I mean, you just can't do it by unilaterally and say, oh, this is the way. I mean, there's a lot of process. There's a lot of hearings. There's a lot of commentary about this.
That's exactly right, and that is reflected in the record of the number of meetings that the DNA subcommittee had. Of course, Your Honors are familiar with the membership of the DNA subcommittee, which is staffed with scientists and ethicists who understand these matters and have been chosen by the legislature to make these judgments. And this is the kind of area where evolving science...
Well, sir, what weight, if any, should we give to the fact that the legislature, particularly the Senate, looked at this specific issue, and ultimately the legislature took no action, was unable to come to an agreement as to whether there ought to be familial searches at all?
On the facts of this particular case, not much weight at all, Your Honor. As we lay out in the Boreali Part 3 analysis in our brief, bills that die in committee, the Court of Appeals has given very little weight in the Boreali analysis, and actually this court in the New York State Land Title Association case also recognized a case where the passage of a bill by one house of the legislature where it's never really debated and the other house of the legislature doesn't get very much. Since Boreali itself in 1987, The Court of Appeals has essentially never given much weight to Boreali Factor 3, and has, for it to be demonstrated, it would require an extremely protracted level of legislative gridlock, such as we don't see.
Well, you know, I look at that as actually supporting your argument that, you know, that's why it was delegated, as the rulemaking authority was delegated to you guys, because the legislators knew in itself, internally, they're not going to be able to get, they're not going to get it done. And then this stuff, you can't wait around for it.
That's exactly right, Your Honor. And in fact, there's another Court of Appeals case that we cite in our brief where they explain that just as often when the legislature looks at something and ultimately doesn't act, it just as often is going to reflect a judgment that the existing statutory delegation of authority to the administrative agency is sufficient and that no new delegation is required.
Well,
In this case,
I have to say, one of the things that concerned me in looking at the regime that was ultimately adopted by the agency is that the review about whether it was an appropriate search or not only went so far as the head of the agency, whereas in our jurisprudence, in our criminal jurisprudence, usually when you want to get at something that's private of an individual, you need to get a warrant. Does that implicate public policy considerations that are beyond what the legislature can delegate?
It is not, and the reason is that there is nothing that this regulation does, nor anything that the agency could do via regulation that would allow the disclosure of the names that are not already in the database by statute. The only names that can ever be disclosed are people whose names are in the data bank by virtue.
But the search isn't really targeting the people in the data bank. It's targeting their relatives.
It's not targeting anyone. It is using the existing information in the database for the purpose chosen by the legislature to investigate crimes as an investigative lead.
So
and
you
as
don't
Justice,
think, so your analytic look at this is that the family members don't have a privacy interest in their genetic matches. They don't have a privacy interest in being identified.
they don't have a privacy interest in the names that are in the data bank, which are not their own names.
Well,
Why would they not?
Yeah.
That wasn't, you didn't really respond to the question. Why would they not have a privacy interest? They did nothing. Their only, not even crime, but their only relationship to the data bank is because they perhaps had a relative or has a relative who committed some type of a crime wherein his or her DNA would be in the data bank.
But as we lay out in our standing argument,
Well, let me put it. Let me ask you this then. I mean, that's where my trouble is that I'm having concerns about in terms of the Fourth Amendment, the search of a person's database. We don't have that. We don't have those kind of arguments that are ripe for review at this point because the individuals weren't actually. I mean, if they were arrested or brought in, yeah, then you'd have a real ripe search, you know, a violation of their constitutional rights, you know, that prevents unlawful search and seizure, right? I mean, then they're going to argue, wait, you got me because of the DNA of my relative, not because of me, and that violates my privacy rights. And I mean, that's where it really comes in at that point. Here, we're kind of just hypothetically talking about what may happen, what may not happen, because the two individuals here have not, at least to my understanding, this record, nothing's happened to them, right?
That's right, and you've summed up exactly the basis for our standing argument, and you put your finger on the one place where the court below went astray on standing, is that the court assumed that if these particular petitioners didn't sue, that there could be no review of the statute. But Your Honor has just identified that in a particular case, if someone has actually been arrested, there would be opportunity to challenge the Fourth Amendment issues that Your Honor
And that's where your DNA, the familial DNA, can actually maybe go down in smoke. I mean, we'll see what. I mean, that's where the arguments are going to come up, and they're going to be ripe for review at that point.
In criminal cases as well.
Yeah.
I still don't understand, though, why I would not have a privacy right, because there's still the potential that there would be some type of, that there could be some type of conduct against me because of a relative whose DNA is in the data bank. So I still do not understand why I don't have a privacy right.
one's privacy right is in one's own body and one's own information. But nobody here is facing, none of the petitioners.
That's my information, right? Because of this relative.
But it's not. But your information. But the petitioner's information could never be found or disclosed as a result of the regulation that was adopted here. And as we lay out in the standing section of our argument, the chain of events that would have to occur before either of these petitioners could ever face any sort of effects from this regulation is so speculative that under this court's decision in Cubas versus Martinez, the petitioners do not have standing. But even if the court were to conclude that they have standing, we would ask that the court affirm on the merits.
I have one more question. How is this search any different than, say, a fingerprint that's found at a crime scene, and searches are made through various databases, et cetera, to find matches? Is there a difference between the two investigatory techniques?
There's not, Your Honor. I mean, that's exactly what this is. It's using information that is already legally and constitutionally in the possession of the government to obtain an investigative lead. And as Justice Owing pointed out with one of his questions earlier, the argument that my adversary is making would under their logic that the agency exceeded its authority, the agency would not have the authority to adopt this regulation no matter what safeguards it built in, which goes too far.
Well, I'm not sure that that's their argument. Again, I think that we're not really concerned here with whether this is a good investigative tool or not. Just who has the authority to make the decisions related to it. And if it is, my understanding of Borelli is that if it is so laden with public policy that is non-delegable by the legislature, it's not that this blue ribbon panel didn't exercise really smartness in doing it, as you indicated that they really are qualified, but that that the legislature couldn't give them the authority to make these very complex policy decisions. And that's really the crux of this case for me, whether they could or could not.
But the legislature made sufficient policy judgments in this case that problem is not realized. They made the judgment about whose DNA would be collected, whose DNA could be disclosed.
Well, they couldn't specifically do that because they didn't know about family DNA, but okay. I understand your argument. All right, let's hear a rebuttal. Yes, never mind. We're going to ask you another question.
Of course.
With respect to the standing, something's really troubling me here, that there is a risk. The significance of the risk, obviously, there's a disagreement about. But before the regulation was promulgated, these individuals who are challenging this were not subject to any sort of investigation stemming from a DNA test or result, correct?
Correct.
Now, the regulation is promulgated, it is in effect. There is now a potential, however minimal that potential is, there's now a potential that they can be subject to an investigation as a result of a familial search. We all agree on that. Again, that the materiality or the extent of the risk is debated, right? There is this risk now that wasn't there before.
I guess my answer to that would be to return to the question that Justice Singh asked a few minutes ago, where he said that this is comparable to other instances in which you search a crime scene or use other evidence that the government has already lawfully collected, but you use it to generate leads, which may lead you to someone who is someone.
Right. So what I'm asking is, there was now a risk that wasn't there before, right?
There is a possibility that and it is a remote possibility that a relative's DNA could result in the disclosure of the name of that relative.
Okay, that's fair. And so, with respect back to the standing argument, we have now subjected a class of individuals who is exponentially larger than those who make up the database itself to this potential of being investigated by virtue of a familial search. And yet we're telling this entire class of people that you don't have standing because it's remote. So they're subject to this risk, however remote it may be, and at the same time it seems like we're cutting off any meaningful route of challenge, putting aside the merits, any meaningful route of challenge to this entire class.
Well, that was the holding that the court below reached on standing, but as I said earlier, my answer to that goes to the point that Justice Owing made a few minutes ago, where he said that, you know, if this were to come up in a criminal case, there would be an opportunity. If a person actually faced, actually was identified based on a lead that was generated from a familial search, there would be an opportunity for review. The chance that either of these two petitioners will ever be in any way affected by this regulation is so remote that it doesn't meet the requirements for standing under KUBAS. Unless the court has further questions, we would ask that the court either dismiss for lack of standing or affirm on the merits.
Thank you.
Thank you.
All right, rebuttal?
Your Honors, my adversary stated that the legislature made the policy judgments authorizing the FDS amendment because it appointed the DNA subcommittee and because it authorized the agency to solve crimes. That is disingenuous. The purpose of the commission and the DNA subcommittee was largely to develop a program of accreditation for laboratories in New York State and to ensure that those laboratories were operating at the best scientific standards practicable. When it came to the databank specifically, the legislature authorized respondents to only promulgate standards to determine matches.
Yeah, Counsel, I saw that in your papers, and that was a question that I had. What was the authorization given to respondents by the legislature? Was it only to promulgate these was it to promulgate standards in terms of familial DNA, or was it in terms of the testing labs, et cetera?
With respect to the DNA databank specifically and the uses to which the DNA in the databank could be put, they were authorized to promulgate standards. Now, they were also authorized to promulgate standards about DNA testing.
Well, hold on a second. More specifically, standards for matches, correct?
That's correct.
And isn't exactly what the committee did, that they promulgated standards for matches here with respect to familial searchers, no?
No, they did not, because as the respondents specifically said in their regulation, only when there is not a match or a partial match would the familial search be conducted. Their authority that was authorized to them by the legislature concerned technical standards and methodologies about forensic DNA testing. That is something entirely
so
different.
in other words, the science changed with DNA, and so the ability to segregate alleles and make matches within alleles within DNA, period, technologically changed. And so one of the things that the forensic board was supposed to do was to figure out scientifically what was the newest and best technology to figure out whether the DNA that they had sufficient alleles to otherwise match somebody in the database. That changed, right? The amount of matter that you needed to get a DNA match. All right, I'm going to withdraw the question. I could see it's right. I'm going to withdraw it. It's okay. I'll look into that myself. I believe that that's part of what was happening here.
Right. I would just note, Your Honor, that the technological authority that was delegated to the respondents largely concerns forensic DNA testing, which is about the standards about how you test the physical samples of forensic DNA. It's not about the uses to which the information...
And what constituted a match? Because it scientifically matches, the definitionally matches changed. The science changed about what's a match.
But the purpose was always to identify an exact match.
Wait, we're not talking about the purpose. I'm just talking about the technology, what they needed to do. They needed to be able to stay on top of the technology because what qualified when the statute was passed as a match DNA or didn't, it changed because the ability, the scientific sensitivity to DNA changed. And they got more matches because scientifically and statistically, something that couldn't be matched 10 years ago could now be matched directly, having nothing to do with family or not.
That's correct, Your Honor. And the purpose of the respondents' ability in analyzing the forensic technical methodologies is divorced from their authority to implement familial searching here. The expertise that the commission has does not justify their balancing of the privacy interests at stake.
So, counsel, you seem to be arguing that at the point where there was no match, that they should have just said, okay, no match, and therefore that's it. They should not have gone into familial DNA whatsoever.
That's
They
correct.
just
Familial
said,
DNA searching represents a distinct slip from the other uses of the data bank.
okay, fine. So they should have just said, no match, period, no familial DNA, and then how would we then make any determinations as to familial DNA? Should have just said, legislature, you have to decide this, or we're not going to do this, or what should have been done at that point?
That's correct, Your Honor. Only the legislature was authorized to make the decision. The legislature was permitted to decide whether to implement familial DNA searching because the legislature has the expertise and the judgments about when these types of searches should be conducted. Who should review the familial search
I'm
application?
not sure they have the expertise, but more to the point, you're arguing that they had the responsibility. I'm not sure they were smarter about DNA than this blue ribbon panel, but I don't know that that should figure in.
But we're referring to the social policy issues underlying the FDS amendment. That is where the agency here lacks the expertise and authority. The DNA subcommittee is comprised of scientists. They have no place making decisions about...
Maybe they do, maybe they don't, but it's just not the way we work. That's a different argument. I wouldn't, I don't think... For me, I wouldn't say, the legislature is just smarter about social policy than the blue ribbon panel. What I would say, though, is that the legislature has the responsibility in our government, to make public policy decisions.
That's correct, Your Honor, and that goes to the first two Boreali factors. The expertise goes to the fourth one.
With respect to standing, as a result of the partial match, petitioners are at an increased risk or a heightened risk of being a subject of an investigation, right?
When you say partial match, Your Honor, you're referring to the partial matches as defined in the regulations. That's
right.
the inadvertent match that arises.
Right. Are they, as a result of the partial match, they are in some ways at a heightened risk of being investigated, even though their DNA isn't in the database, right?
To the extent they are, it is entirely different than the peculiar risk involved by the result of the familial search, because now law enforcement has the ability to intentionally look for new matches only when there is no partial match.
So it all just comes down there to the difference between partial and familial will just be a matter of intent.
Yes, but that intent is critical because the intent is what imbues the social policy judgments the legislature was only authorized to make, and it's what also causes this peculiar risk by virtue of being biologically related to someone who has DNA in the data bank.
Counselor, I have a question with respect to standing as well. And we've touched upon the issue with respect to whether or not your clients suffered actual injury. It's not clear to me they have. But in any event, with respect to the second prong, zone of interest, sought to be protected by statute, how do your clients fall within that statute? Because their DNA certainly is not in the database.
So first, on the zone of interest analysis, Your Honor, respondents don't address the FDS amendment zone of interest, which is also independently sufficient to confer standing. With respect to the statute does not need to explicitly refer to petitioners here in order for them to be within the zone of interest. That's an overly narrow view that the government is advocating for by specifying the class of New Yorkers whose DNA records would be subject to the data bank and subject to increased investigation. The legislature was inherently protecting the privacy interests of those who did not commit crimes that subject their DNA to be included in the data bank. And so the privacy interests here of those individuals who do not commit crimes is implicitly recognized within the statute, and that's why they're within the zone of interest. And in terms of the regulation, they're also certainly within the zone of interest of the regulation because the regulation specifically brings the petitioners within its investigative sweep solely because they are biologically related to convicted offenders.
But you would agree, wouldn't you, that it's somewhat speculative because there are so many steps that have to be gone through to get to the point where they're subject to a heightened investigatory police encounter, no?
No, but the risk of being subject to an increased investigation is the injury here, and under New York law, which is extremely liberal on
But why
standing,
isn't it speculative? Why is it not speculative given it has to be a very serious crime? There's regulatory requirements in terms of when the searches can be made, et cetera, et cetera. What are the chances of your clients actually being caught up in this?
By virtue of the amendment existing, petitioners now know that there is a distinct and real possibility that they may be the subject of a law enforcement investigation solely because they have.
But that's true for all of us, right? Aren't we all subject to it too in some fashion? You know?
No, Your Honor. I mean, the peculiar risk of being subject to an investigation here that Supreme Court recognized is sufficient. It's exactly like the risk that was recognized by this court in Leno. The petitioners there didn't have to wait for their.
And is Leno the best case that you have for standing?
I would submit that it is, Your Honor.
Okay.
And finally, to conclude, with respect to standing, we are not asserting a Fourth Amendment violation here. The standing issue is about Article 78 review based on separation of powers and non-delegation. And so the whole speculative aspect of whether they're going to be subject to an actual search is irrelevant. The injury here that matters with respect to Article 78 review is simply the risk of being subject to an increased investigation.
Okay. All right.
If Your Honors have no further questions, I'll submit that the opinion below should be reversed, the petition should be reinstated, and the regulation annulled. Thank you.
All right. Thank you. Thank you both. Very interesting argument.
Lobby, be advised, court is over. We have 2 coming out.